Mr. Fishburne?
We request apparent danger be included in the charge because it is on this jurisdiction. And parties are going to be able to argue whether it was reasonable to apprehend the danger, and the jury needs to know about that.
Okay, Mr. Gladden?
Judge, the language of apparent danger proposed by Mr. Fishburne is not the law. Under the penal code, the case law doctrine that a person can defend himself against an attack that he believes to exist just as much as a real attack has been held by the courts to be encapsulated in the statutory definition of reasonable belief, and that Court of Criminal Appeals and the Dallas Court of Appeals, this jurisdiction, have said that that is the appropriate charge for a justification based on reasonable belief.
Well, they've said that's adequate, and we believe it is inadequate, and we would request it go in.
And the specific request that I have before me is you're wishing to use this language. An individual has a right to defend himself from apparent danger to the same extent as he would had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him at that time.
Yes, for self-defense, and then another one for defense of a third person with that added to it.
All right, and I'm going to overrule your objection, but I agree that that is an argument that can be made. It just can't be contained in the jury charge according to our Court of Criminal Appeals and to the Dallas courts, in my opinion. So parties can argue it. It's a valid form of argument, but it's just not in the jury charge. It's, to me, a definition of what's reasonable. So number 2 is the request by the defense that the mental state of reckless should be out of the jury charge. Mr. Fishburne.
There is no evidence in this case that the defendant acted with the culpable mental state of reckless. He saw the threat, he sighted the target, he hit the target intentionally or knowing that it would likely cause the result. There was nothing reckless about what Officer Hess did.
Any reply?
Yes, Judge, the evidence shows that the windows were fogged up, the officers could not see into the car. Officer Hess could not sight his target. He shot a gun into a car that he at best knew was occupied because it was being run. That's being aware of but consciously disregarding a substantial risk that bodily injury will occur to a person in the car. There's plenty of evidence in this case about his training, about the use of firearms with sighting his target, being aware of his background, and the fact that he could not see into the car when he made the shot. So the issue of recklessness has been raised by the evidence, and in addition, it's in the indictment, and it's what he pled not guilty to. So the issue is joined on that allegation.
It is not joined, and it is not in the case. He shot 12 times, did not shoot the last time because the threat was stopped, and he hit his target 5 times, twice in the neck, once in the shoulder, and twice in the arm. There was nothing reckless about it.
Okay. The objection's overruled. Next up is the state is requesting self-defense not be in the charge, if I understood correctly.
That is correct, Judge.
Go ahead.
The state's argument is that for a defendant to be entitled to an instruction on a defensive issue, there must be some evidence that would raise every element of the defensive issue. The elements of self-defense are a belief that force, when and to the degree used, was immediately necessary to protect himself against force. A belief that deadly force, when and to the degree used, was immediately necessary to protect himself against the use of deadly force, and that those two beliefs be reasonable. That is, that those beliefs be held by an ordinary and prudent person in the same circumstances. I've been sitting in this entire trial taking copious notes. There is no evidence in this trial that the defendant believed that Genevive Dawes was using deadly force against him. There is the video showing some evidence that he believed the car might have hit the other 2 officers, but there is no evidence that at the time he shot, the defendant believed that any deadly force was being used against himself. And so there is no evidence to raise that defense at all. We're not talking about incredible evidence or contradicted evidence or impeached evidence. We're talking about no evidence of what he believed about the use of deadly force against himself. And so it hasn't raised the issue of self-defense.
Mr. Fishburne, what do you think?
There's ample evidence. First of all, he's got to be justified to defend himself before he can defend somebody else. And
That's not quite right.
Well,
it's right enough on the facts of this case. The car was backing toward him. He perceived the threat. He also perceived the threat to the other officers. And I would submit he perceived a threat, deadly threat, to all of the officers that were present, not just Kemble and not just Hopkins. And there's ample evidence. There is at least a scintilla of evidence raised in this case to authorize the jury to decide for themselves whether or not he was justified in using deadly force to defend himself from a deadly attack.
Okay. Mr. Gladden, go ahead. You wanted to say something.
Sure, Judge. Two things. One, there's certainly evidence that officers on the scene believe that that car might be turned and directed toward them in the future. But self-defense requires a belief that it be immediately necessary when used and to the degree used. So we have that contemporaneity requirement. You can't defend yourself against what you think might happen even 5-10 seconds down the road if 3 other intervening circumstances occur that you don't actually know will happen. At the moment he used force, the car was turned and backing away from him. There is no testimony that he perceived any threat to himself when he used deadly force. And then the second response is self-defense is not required for the defendant for him to claim defense of others. The defense of others statute requires him to believe the circumstances to be such that if he were in the position of the others, he would be able to use self-defense. In other words, he has to reasonably believe that those others could have used deadly force. That's putting the defendant, as alleged, behind the Dodge journey, not by the squad car, where there is, again, no evidence of any threat being directed in that direction at the time the shots were fired.
He is parsing the facts too finely. It's a fluid situation that occurs very quickly. Mr. Gladden's position would be, well, let's see if he's going to get run over or not. Maybe when the wheel rolls over his foot, he can shoot then.
Okay.
We submit that it's in there.
All right. I do find that there is some evidence to support the inclusion of self-defense as well as defense of a third person. So I'm going to overrule your objection, Mr. Gladden, and include the charge of self-defense as well as third person in there. There was also this objection by the state about, I believe it was by the state, about including deadly force to effect an arrest, essentially. You want to articulate that for the record, please?
Yes, Judge. Same standard applies. There has to be some evidence raising every element of a defense for it to be submitted to the jury. And the elements of deadly force by a peace officer making an arrest are, you have to have a peace officer. He has to reasonably believe that deadly force, when and to the degree used, is immediately necessary to make an arrest. So you have to have a belief that's reasonable. He has to reasonably believe that the arrest was lawful. So you have to, again, have a belief that was reasonable about an arrest that was lawful. And then there are the elements of, before using deadly force, he has to either manifest his purpose and identify himself, or believe his purpose is known or can't be made known, and reasonably believe that the conduct for which arrest was authorized included the attempted use of deadly force, or there's a substantial risk of death or serious bodily injury to himself or another if the arrests were delayed. Certainly there's been a lot of evidence in this trial that the defendant was a peace officer at the time. Certainly there's been a lot of evidence in this trial that other officers on the scene believed that if the defendant did not shoot into that car at that moment, that there was a substantial risk that the car would turn around and drive towards the officers. But what there is no evidence of here is what the defendant believed with respect to an arrest. The defendant said he thought the car was about to strike Hopkins and Kemble. That's it. That's the only evidence we have of what the defendant believed. The defendant never told anyone that he was arresting anybody. The only evidence in this trial in which the word arrest was used was from Officer Ailish's testimony that he believed he was arresting the people in the car for unauthorized use of a motor vehicle, but then what he said was that he was going to get them out of the car to investigate whether the vehicle was stolen. That's not an arrest. That's an investigative detention. And the facts that Officer Ailish based that on are not legally sufficient to justify an arrest. If Ailish had gotten the two people out of the car at gunpoint and arrested them for having a stolen car at that point, that arrest would not be supported by probable cause, because all he had at that point was a report that the vehicle was stolen. He had no identifiable facts about whether there was effective consent to use the vehicle or who was even using the vehicle when he made the decision to detain the people. But all that's in Officer Ailish's head. We don't have any evidence of what's in Officer Hess's head. And so there is no evidence in this case that the defendant believed he was making an arrest, much less that the arrest was lawful at all.
Mr. Fishburne?
The Officer Hess's belief is evidenced by the surrounding circumstances of this event. The complaining witness's conduct was arrestable when she started driving toward the officers, when she started driving through the fence. There is ample evidence that those people were going to be arrested as soon as they got them out of the car for the stolen vehicle. You had officers conducting a felony stop. They were there on a report of a stolen vehicle. There were repeated refusals to adhere to the lawful commands of the police, and to argue that there was no basis for an arrest immediately is incorrect on the facts. And then to argue that there was no basis for the arrest based on Ms. Dawes' conduct with the car and the likelihood that the arrest would have been delayed and they let her go careening down that alley, she wouldn't have hit somebody else. So this is among the facts of the case and should be submitted to the jury. Let them decide.
All right. The state's objection is overruled. There is the request to have certain terms unbolded by the defense. I'm going to overrule your objection. There's a request by the defense to have included in the charge from the Code of Criminal Procedure the duty of a peace officer.
Yes, sir.
And I want to read that real quick. Maybe. Okay. What I have submitted by Mr. Fishburne is the following language. It is the duty of every peace officer to preserve the peace within the officer's jurisdiction. To effect this purpose, the officer shall use all lawful means. Mr. Gladden, do you have an objection to this?
Yes, Judge, multiple objections.
I'll probably only need one. Let's do one at a
Certainly.
time.
Well, I'll make one objection with multiple supporting theories. I don't know how else to word it. The jury charge has to contain the law applicable to the case, instruct the jury on how to analyze the facts of the case, and avoid confusion. That is the purpose of a jury charge. Here, the definition of duties of peace officers from the Code of Criminal Procedure doesn't fit into any of those categories. It doesn't tell the jury the law applicable to the case, because what it says is that peace officers have a duty to use lawful means. Whether the defendant in this case, as a peace officer, used lawful means is a fact question for the jury in this case. So to tell the jury that he had a duty to follow the law when that's not an element of a defense, it's not an element of an offense, doesn't give the jury any guidance, and it potentially confuses the jury about what we're actually deciding here.
All right. Mr. Fishburne?
It puts the jury in the position to put Officer Hess in context with all the other officers so they know what their duties are as they go out there. Their duty is to lawfully discharge the application of the laws.
Okay.
And that's all it is. It's just explanatory in its background and its context in which we're operating.
All right. Your request is denied. Next up, we've got a request by the defense to have certain language included that is as follows. Now, bearing in mind these instructions, If you unanimously find the state did not disprove Officer Hess was justified in using deadly force to make an arrest beyond a reasonable doubt, or if you have a reasonable doubt whether the state disproved Officer Hess was justified in using deadly force to make an arrest, you will find Officer Hess not guilty. It's my understanding that Mr. Gladden had some objections to this language. Mr. Gladden?
Yes, Judge. I believe that the penal code, in talking about defenses, says that if the issue of the defense is raised, the court shall instruct the jury that a reasonable doubt on the issue of justification requires that the defendant be acquitted. That's what the code provides for. And that's what this court has put in the charge on page 4, where it says a defense to prosecution. It is a defense to prosecution that the conduct in question was justified. You are instructed that a reasonable doubt on the issue of justification requires that the defendant be acquitted. Anything beyond that is more than what the code provides for. It's not the statute, and it's not appropriate for the jury charge, which again is to tell the jury what the law is, show them how to apply it to the facts, and to avoid confusion.
Mr. Fishman?
The purpose of the jury charge is to guide the jury clearly in their application of the law to the facts. A instruction that you read into the record in the active voice clearly demonstrates to the jury how they're to handle the elements of justification as to the burden of persuasion, and we requested it be in there.
I believe that the charge as written adequately explains the law and clearly does so. Your objection is overruled. Finally, we have, I believe it's finally, and I'll ask y'all if you have any other ones, but there's a series of instructions that are at the end of the jury charge. Instructions not the right word, forms maybe. One of them says, ask the jurors to request, all of the evidence that was admitted. It's my common practice, I think in every trial I've done, just to, with the consent of the parties, to send all of the evidence back as soon as they deliberate, as soon as they begin their deliberations. I plan on doing that again in this trial, so that would make that form needless in my mind. So I'm going to take it out. Any problem with that, Mr. Gladden?
I don't have any problem, Judge, except on the final page of the jury charge itself, which is page 11, the top paragraph only talks about that form, so if the form is removed, it would render that paragraph superfluous. It says, during your deliberations, you are entitled to view any or all exhibits admitted as evidence in this case. A suitable form for requesting such evidence is attached in this charge after the verdict form. I think it's probably still fair to tell the jury they're entitled to view all the evidence, but if the court's going to send it all back and not have the form, I guess we take out the sentence telling them that there's a form.
Okay. Now, I'll do that, and while I'm doing that, is there anything else from the state?
No, Judge.
And is there anything else from Mr. Fishburne?
Yes, Your Honor.
Okay.
On page 5, right above where it starts off deadly force in defense of a third person, I'm referring to the paragraph above that. It would be called the sequencing instruction, and I object to the way that is written as incomplete. I submit that it should read, if you do not so find and you do not have a reasonable doubt thereof, or you have reached no decision, you will next consider defense of a third person. Justification of deadly force in defense of a third person.
I think reaching no decision is the exact same thing as not finding.
It is.
It would be redundant.
It allows the jury to consider the jury charge in any order they want, which is the law, and it doesn't confine them. So if they get back there and they, for example, say, we're not sure about self-defense, and they're having trouble coming to any sort of an agreement, that instruction allows them to move on to defense of a third person without first making a decision on self-defense.
So you wanted to read, if you do not so find, and then what?
And
This wasn't one that we talked about. Go ahead.
no, and if you do not so find, or you have and you do not have a reasonable doubt thereof, comma, or you have reached no decision, you will or you may next consider the justification of deadly force in defense of the third person. It allows them to skip around in the jury charge.
All right, there's, your request is denied. Is there anything else?
Yes.
Okay.
The same request on page 6, the sequencing paragraph between defense of a third person and deadly force by a peace officer making an arrest.
Same response.
All right, the objection is overruled.
And I have one more thing.
Okay.
There is no duty to retreat when you defend a third person. I request that that be put in there on page 6, as it was earlier in the charge, after.
No, Judge, that's
Two.
not, that is not correct. 951 says there is no duty to retreat before using force as a peace officer making an arrest. The defensive third person statute says that if the circumstances are such that you, as you reasonably believe them to be, you would have been justified in using deadly force to protect yourself. So that refers into the justification of self-defense, which has the no duty to retreat language if the certain conditions are met. If you look up Penal Code 933, there is no sentence that says there is no duty to retreat before using force as described by this section. That's not in there.
If
Mr.
it's
Christopher?
immediately necessary to defend a third person, the law can't be that I've got to retreat before I do so. And I request that that be in there for that reason.
And that is adequately covered by the statutory language. If the defendant reasonably believed that his intervention was immediately necessary, whether he reasonably believed that, A, whether he believed it, B, whether it's reasonable, is a fact question for the jury. To add something that's not in the statute is at best a comment on the evidence, and at worst, not as the correct statement of law.
It is a correct statement of the law, and you can't have the jury back there arguing about whether or not Officer Hess had a duty to retreat before he defended Hopkins or Kemple, because he didn't. It's immediately necessary. Imminent means I must act right now with this amount of force. There is no time to retreat in defense of a third person. It's like that, and a split-second decision has to be made.
I'll agree to that if Mr. Fishburne can show me where in section 9.33 that is at.
Doesn't have to be in there. It's the law of defense of a third person. The law is it has to be imminently necessary in a split second to step in and intervene to protect that person. There is no duty to retreat.
All right, hold on just a second. All right, the request is denied. Morales versus the state, 357 Southwest 3rd 1.
That's the case I was thinking of.
There you go. Court of Criminal Appeals. Okay, are there any other requests that you have? Mr. Gladden?
No, Judge.
Okay, then let me go off the record. I'm going to print the jury charge. I want to talk to the lawyers. Mr. Prosper, Ms. Manson, we're off the record.